YouTube, it's Tone. I'm back with another one for you. This slide here it has to do with collection dispute letters. So you're gonna use these when you're gonna be questioning the integrity of a loan or even somebody's authority to be sending you bills in the first place, because ultimately any bill that you get is a outward remittance basically showing the amount of credit of yours that has already been used. So when you get a bill, it is not for you to pay again. It is a remittance, and they need you to endorse it and send it back to them. That's what they're asking you for. And so when you end up in situations where you're fighting with these people back and forth, it's probably because they really don't fucking know what's going on. You're dealing with the wrong people. So when you're dealing with anything that has to do with finances or any companies in general, you want to send your correspondence directly to a binding agent that you are going to be able to hold responsible for not fucking doing their job. You're not going to send it just to the company at all. You know what I'm saying? Because you're going to have somebody physically able to be liable and responsible for the correspondence to be able to be held accountable, because they will be. And the only way that you can do that is if you're dealing with a actual person directly. Sometimes you may find that it's hard to even get these people to sign shit, say who they are and things like that. It's for a reason, because they know what the fuck they're doing. So just keep that in mind. So when you look at this here, what we're going to get into is the things that you're going to need. Dispute letter instructions. So each letter is to be duplicated 3 times, addressed separately to each of the 3 main credit bureaus: Equifax, Experian, TransUnion. This is if you're dealing with agencies that are divulging your personal information unwarranted without a contract. That shit is highly illegal. Highly illegal. Because you can't, first of all, you're protected as a consumer in general, which means that any derogatory information has to be they have to have a contract with you essentially in order to be able to, publish any of your private information for one, let alone derogatory information that ends up causing causing hardship, right? So that's not part of the game here. So each letter has a place for a notary, and so you send it to them 3 different times. The reason why you do it 3 times is because that's how many times it takes them to how many times it takes you to perform a perfect administrative lien on them, and then to be able to essentially get your summary judgment before you even have to go into court. You already have your case done. That's going to be through a notary. First time you send it is just going to be a notice. Second time is going to be a opportunity to cure. And the third time is going to be a default. That is when you have summary judgment and the case is already won. Okay? So each letter has a place for a notary to notarize your letter. This is not essential, but can be helpful. Most local banks offer free notary services to their customers. Do not sign the letter until you are in the presence of a notary public. Include a copy of 2 forms of ID when sending dispute letters. Proper forms of ID are listed below. You got your driver's license, your state ID card, bank or credit union statements, canceled check, government ID issued, signed letter from the homeless shelter, and that serves as ID as well too. You don't gotta have an actual government ID. You can have a piece of paper notarized by 2 people, aside from to sign by 2 people, and then get that notarized, and that's gonna serve as an ID, and actually holds more value than a fucking piece of plastic, because you have actual people backing the shit up now. So stamped by the post office box receipt, utility bills, gas, water, electrical, telephone, or your pay stub. It is extremely important to send the correct forms of ID. If they are not sent, the bureaus will ignore your request or reply with a request for you to send the correct information. So either of these will increase the time needed to get the books right, to get the book on the road and the best possible credit for your situation. So keep that in mind. Always going to be using a notary. You know what I'm saying? If you ever wonder why they act like they never got your shit, it's because they can. Because a notary didn't fucking send it. So always use a notary to send that shit. What do we got here? Okay. So here, it is extremely important to send the correct IDs, and that's the thing. So just keep that in mind. Also use the notary every single time. Do not dispute more than 22 derogatory items at once. Otherwise, the credit bureaus might mark your disputes as frivolous, as if their fucking claims are not frivolous. You know what I'm saying? But anybody can say anything, and if they say it's fucking frivolous, ask them to tell you how. And ask them to tell you how their shit is not fucking frivolous. So in the dispute templates, replace the bold red content with your personal information. Keep good records, date and record everything you send and everything you receive. You're gonna process everything as if you're gonna go to court. So every document you get, itemize it. You can do A1, A2, A3, go up and down, so that way you can use them as a fucking exhibit if you ever have to go into court. Trust me, you may have to. And just make sure that you always send an invoice with this shit as well. That way it's worth your fucking time to go into court and hit them for whatever you feel is worth. So do not give up or get scared in the process. Regardless of what the credit bureau sends you, if the derogatory item is not removed from your report, proceed with the next letter. Go through all of the training videos so that you fully understand the process and how to improve your credit score. And so, when you first start the process of disputing anything, the claim has to stop at that point. They can no longer send you bills and shit like that too. So this would also apply in court because 15 U.S.C. is going to apply to all commercial venues, including these fucking corporate courts. All of them are corporate. So up here is going to be where you're going to put your name, your address, city, state, zip, your social security number. If they already have it, more than likely they do. It was illegally gained, obviously, because if you have no contract with them, then they're not authorized to even have your fucking social security number. That's identity theft and things like that too as well. There's a lot of fucking things here. Mail fraud. I mean, you can go on and on. So right here, you're gonna put the credit bureau's number, the address, state, city, zip, state, zip. So whom it may concern. Whoever the fuck that is, right? So please accept this letter as my formal written request for the following items on my credit report to be investigated. According to the Fair Credit Reporting Act, 15 U.S.C., and that's where you're going to find your remedy. Even in court situations, you can apply this as well because they're all just third-party debt collectors. And I'm not talking about court situations where they're just calling it commercial and all that. I'm talking about criminal charges and all that. That's all going to fall under 15 U.S.C., third-party debt collectors. So you are required by federal law to verify. So, essentially what you're asking for here is a forensic audit of all the fucking accounting and proof of your contract with them in wet signed ink that they were authorized to even publish your information to begin with. I called these people at one point about a year or two ago and dropped it on them over the phone, and they took and they took the shit off within a week. You know what I'm saying? I just let them know how much I was going to be charging them if when I look back on there, if it was still there. It's a recorded line and everything. I was like, hey, look, is this a recorded line? They're like, absolutely. I'm like, fucking awesome. Listen, because you're going to need this shit for court. So make sure you send this shit to your legal team, right? Dropped it on them, their whole scam, the whole fraudulent game and all that shit. And I'm like, look, I know that you just work for them and this has nothing to do with you, but let me just break it down what it is that's actually happening here. Okay? So what you're doing is this. So they're going to take your fucking account from somebody else, right? A different agency. They're going to buy your debt outright, which obviously means that it's fucking discharged, because if it goes from one count to the other, it's already discharged. So now you're going to reopen a claim with somebody that you don't even fucking know. You're going to start claiming that I owe you XYZ every month or quarterly, however you're going to do it. You're going to be claiming the fucking exemption based on the fact that you're taking a loss from the money that I'm not giving you, that I never fucking agreed to give you. So you're going to be claiming that on your taxes, taking the loss, right, or the exemption off of that debt that is not even fucking authorized for you to be publishing at all, for one. And then you're going to go ahead and still try to charge me the full amount after you already received exemptions on it. So you're already receiving credits on it on one side, and so the public side should reflect the credits that you've gotten on the private side, but they don't. So you're going to keep on sending me fucking bills after you already got credited on the private side, and so you're not making the public side mirror that as well, the actions that were taken on that side. Illegal, okay? Your books are fucked up. You're grimy. So this is what I just broke it down for them way more detailed than that over the phone. Beautiful, beautiful case laid out verbally, right? So of course they dropped that shit because they fucking have to. The fuck out of here. So I demand to see the verifiable proof. So look, you are required by federal law to verify through the physical verification of the original signed contract and any and all accounts you post on a credit report. Otherwise, anyone paying for your report services could fax, email in a fraudulent account. So they have to verify all that shit before they even start publishing that. And I mean, for all they know, the account that they bought off somebody else could have been fraudulent just as well, and they wouldn't know because they never contacted you to find out. So I demand to see full verifiable proof, an original consumer contract with my signature on it. You have on file of the accounts listed below. Your failure to positively verify these accounts has hurt my ability to obtain credit. Under the Fair Credit Reporting Act, unverified accounts must be removed, and if you are unable to provide me with a copy of verifiable proof, I wouldn't even say a copy. If you're not able to provide me with a original verified proof, you must remove the accounts listed below. I demand that the following accounts be verified and or removed immediately. And here you're gonna go ahead and number whatever accounts that they're claiming on here that they've not ever verified. I know that at about a year or two ago, everybody was doing the disputes and just put because they only have 30 days to fucking prove it or take it off. Everybody was just fucking hitting them at once to do it, knowing that they wouldn't have enough time to check them all, so they were literally having to take off accounts that were actually fucking legit. So they were taking off fucking legit accounts because they didn't have enough people to verify all the shit that they had to do within the 30 days. So people were getting shit that they actually owe taken off too, which you can do too. Yeah, it's funny. So please add a promotional suppression to my credit file, meaning that for the duration of the time that you're doing this, what do you call it? This process to make them prove their claim, they're gonna have to take that shit off. So in witness there whereof the said party has signed and sealed these presents, the day and year first above written, signed, sealed, and delivered in the presence of XYZ. It's gonna be your name, state of, and so this is for the. So I hereby certify that on this day before me, an officer duly qualified to take acknowledgments, personally appeared, your name here, who is personally known to me and who has produced XYZ as identification, and who executed the foregoing instrument, and he or she acknowledged before me that he or she executed the same. The witness here, and then you get your notary to go ahead and stamp that. You know, you can rearrange that however you feel more comfortable with. And definitely make sure that if you don't understand any of the language that's on these particular documents, that you get a dictionary, a Black's Law dictionary, and look these up. Or any modern dictionary may even work for these specific terminologies. You can also go Cornell Law. You can find that online. They have an awesome page there, and a lot of things are for free there. And so aren't the legal dictionaries that they offer as well, are free Cornell online. So here you're gonna have your name, your address, city, state, zip, credit bureau, address. So to whom it may concern, this is the second one, okay? So you're gonna have to send them 3 different ones, okay? And if they don't, if they move forward and they're not providing you the information that you asked or fucking demand, then you're just gonna disregard that shit, notice their dishonor in your documentation, and then send them the second document. So it's gonna be this. So please be advised that this is my second written request for you to remove the unverified accounts listed below that remain on my credit report in violation of 15 U.S.C. Clause 1681. So the unverified items listed below remain on my credit report in violation of federal law. You are required under the FCRA to have a copy of the original creditor's documentation on file to verify that this information is mine and is correct. In the results of your first investigation, you stated writing that you verified that you stated in the writing that you verified that these items are being reported correctly. Okay, so they're correctly. Mind you, it doesn't matter if it's fucking correct or not. If you tell them to take that shit off, they're gonna have to take that shit off. Okay? Because if it's hurting you in any way, that's just not part of the game. And so then they would be liable for damages after that. So who in your company verified these accounts? How did they verify them? Please provide me with the name of the individual. And so that's what I'm talking about. You're going to need a name to be able to physically tie a binding agent to this particular incident. So business address and telephone number of the person or business contacted during your reinvestigation. Also, why did you not send me copies of the verification like I asked? So not just verification, but also validation. So verification and validation. I'd go with both. So as I am sure you are well aware, current case law states that consumer reporting agencies bear grave responsibilities to ensure the accuracy of the accounts they report on, and their responsibility must consist of something more than merely parroting information received from other sources. And that's what it is. They're just basically acting like fucking parrots and puppets for another agency that they have not even verified if that account is even valid. I mean, for all they know, somebody committed identity fraud with your shit, opened up a fake credit card, charged a bunch of shit, and then they went and bought that debt, and now what? So now they're part of that, okay? So the courts have ordered that a reinvestigation that merely shifts the burden back to the consumer or the credit grantor cannot fulfill my obligations provided by 1681, which is going to be 15 U.S.C. So you have not provided me a copy of any original documentation required under Section 609, a consumer contract with my signature on it, and that's what they need. Otherwise, it's just fraud. Otherwise, it's just clear fraud what they're doing. And you can fucking report them to the IRS, criminal investigations, and all that too as well if you want to. So promptly delete all the information which cannot be verified. So this is not a question, this is a fucking demand. So the law is very clear as to the civil liability and the remedy available to me for negligent compliance. Section 617, if you fail to comply, I am litigious consumer and fully intend on pursuing litigation in this matter to enforce my rights under Federal Credit Reporting Act. I demand the following accounts be verified or deleted immediately. Verified and validated. Validation is huge too. Anybody can verify that the accounts fucking exist, but is it actually valid? So validation is key as well. Okay? Keep that in mind. So then here, you're going to list all of the accounts that you already listed in the letter prior to this being the second one. And you're going to go ahead and do all the same shit that you fucking did again. And basically what you're doing here for this whole process is you're defaulting them into your summary judgment, which is going to include any of the damages that you've sent with every correspondence, letting them know that if they were not able to verify that they're going to be liable for these particular amounts, which they agree to when they don't address them, and then they disregard your shit. Okay, so this is the third time. So to whom it may concern, please be advised that this is my third written request and final warning that I fully intend to pursue litigation in accordance with Federal Credit Reporting Act to enforce my right and seek relief and recover all monetary damages that I may be entitled to under 616 and Section 617 regarding your continued willful and negligent compliance. Despite two written requests, the unverified items below still remain on my credit report in violation of federal law. You are required under Federal Credit Reporting Act to have a copy of the original creditor's documentation on file to verify that this information is mine and correct. And the result of your first investigation and subsequent reinvestigation, you stated in writing that you verified that these items are being reported correctly. Well, who verified these accounts? I request for the third time that you provide the method and verification you used. Your response should provide the name of the original creditor, the address and phone number of the original creditor, and the name of the person at Experian who verified the dispute with the original creditor. So you have not provided me with any original documentation, a consumer contract with my signature on it as required under Section 609 and Section 611. Furthermore, you have failed to provide the method and verification as required under Section 611. Please be advised that under Section 611 of the Federal Credit Reporting Act, you are required to promptly delete all information which cannot be verified. The law is very clear as to the civil liability and the remedy available to me under Section 616 and 617. If you fail to comply with federal law, I am a litigious consumer and fully intend to continue to pursue litigation in this matter to enforce my rights under the Federal Credit Reporting Act. I demand the following accounts be verified or deleted immediately, right? So then this is basically where you're going to repeat the process that you already fucking did. And you're going to send them another invoice along with all this shit. And you're going to have a notary stamp it all as to what the information that you sent to them actually was. So they're going to verify all the documentation that you actually sent them. So a certificate of service is what it's going to be. So what do we got here? So this is pretty much the same thing. You're going to just list here all the accounts that have not been verified. And you're going to have the notary go ahead and stamp that. As well, you're going to be including all of the notary fees are going to be included in the money that they're going to be owing you as well, on top of whatever you charge for your time hourly or for the whole matter in general. You can assess it accordingly, however you feel is best for you. But they're going to have to fucking pay for that. So then here. This is going to be the fourth thing. So notice of pending litigation seeking relief and monetary damages. Mind you, you don't even have to go to court if you don't fucking want to until, I mean, you really don't. I mean, there's ways to get these motherfuckers to pay, but if you want to go to court, you can. But pretty much when you have your summary judgment and you're using the notary, that is court. Okay, so if you do go into court, it's just going to be for them to stamp it because you already did court, because you already held court through the mail. Okay, so notice of pending litigation seeking relief and monetary damages. And that's it. So you're gonna add up all the invoices that you sent them every single time. You know, whether it's $1,000, $100,000 for every correspondence and time that you had to fucking waste to correct their fucking fraud. You charge them whatever you feel is worth. And so please accept this final written offer. And these are offers, mind you. And if they do not address these offers, then they basically accept them through silent acquiescence, okay? So, which is going to make it legally binding as well. So please accept this final written offer of settlement before litigation as my attempt to amicably resolve your continued violation of the Fair Credit Reporting Act regarding your refusal to delete unverified information from my consumer file. Consumer protection is USC 15. So I intend to pursue litigation in accordance. Litigation is court. So basically, litigation is back and forth in court with the Federal Credit Reporting Act to seek relief and recover all monetary damages that I may be entitled to under Section 616 and 617 if the unverified items listed below are not deleted immediately. A copy of this letter, as well as the copies of the 3 written letters sent to you previously, will also become part of formal complaint to the Federal Trade Commission and shall be used as evidence in pending litigation provided you fail to comply with this offer of settlement. Despite these written requests, the unverified items listed below still remain on my credit report in violation of federal law. You are required under the Federal Credit Reporting Act to have a copy of the original creditor's documentation on file to verify that this information is mine and is correct. In the results of your investigation, you stated in writing that you verified that these items are being reported correctly. I request for the 3rd time that you provide me the method of verification that you used, and to validate, your response should provide the name of the original creditor, the address and phone number of the original creditor, the name of the person at Experian who verified the dispute with the original creditor, and the documentation used to verify the dispute. You have not provided me with a copy of any original documentation, a consumer contract with my signature written on it as required by Section 609. Furthermore, you have failed to provide the method of verification as required under Section 611. Please be advised that under 611 of the Federal Credit Reporting Act, you are required to promptly delete all information which cannot be verified. The law is very clear as to the civil liability and the remedy available to me. So you already know what it is. So then here, the last letter you're going to send them again is going to be the, what do you call it? Just the accounts are going to be listed here. The same exact thing again, okay? And so this is going to be their default. So that's going to be their default right there. Is going to be the number 3 because 3 strikes and you're fucking out of here. You know what I'm saying? So look, man, it is a game of chess. Stop playing checkers with these clowns. That's what I got for you.